Hola a todo el mundo y bienvenido a mi canal. Yo me llamo Sirey. Soy una abogada afro-latina licenciada practicando la ley criminal, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a continuar hablando de Karmelo Anthony. Si quieren más video en español, nada más dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latino criminal attorney who, much like the rest of you, has a severe fascination with true crime cases. Listen. Okay, you guys. I'm sorry. Today we're going to begin our discussion on the 193-page brief in support of a motion for a new trial that was filed by Karmelo Anthony's appeals attorneys. Okay. The reason I sighed heavily is because my throat is going to die. Okay. But again, I do all of this for you guys because I love you. I love you. And I want to make sure that you see how much I appreciate you and see how much, I want to do things that I know that you guys are interested in. I think another thing that I want to talk to you guys about that I don't believe I mentioned in my last video about some of the different things I want to try out or whatever is I'm probably going to have like a little thingy. We're going to call it a little thingy because I don't know what the little thingy is going to be yet, but a little thingy by which you guys can let me know what cases you want me to cover. Isn't that exciting? Isn't that exciting? Just just a thing because I know there are specific cases that you're like, Desiree, I haven't heard you talk about this yet, and I need your opinions. And I will do my best. I will do my best. But I want to make sure that I'm covering cases that you guys are really interested in hearing me talk about. I try to keep up with a lot of the mainstream stuff, but there's a lot of stuff that's not necessarily mainstream that needs detention. Detention needs attention as well. Okay. So I think I'm going to do that. I think so fondly of my mare bear. And if you guys have been here long enough, you've heard me talk about Mary a million times because I love her and she's been with me from the beginning, right? But Mare Bear will tell me about different cases that she wants me to talk about, and I'm happy to do it as long as you guys let me know. I'm genuinely happy to do it. Okay? But anyways, let's go ahead and get started in this extraordinarily long brief that I'm reviewing and analyzing because I love you. But before we get started in the brief, you guys know I love to talk about key players. So let's go ahead and talk about the key players that take part of Karmelo Anthony's pro bono appeals team. What does pro bono mean, you guys? Pro bono literally just means that they're working without pay. So they're just doing it to do it. It's a good cause. They find it to be a good cause and they're just doing it to do it. Do I think that his team that we're going to talk about just momentarily is a team of heavy hitters, impactful attorneys, and attorneys that could make a difference in his overall circumstances? 1,000%. These are some heavy hitters. These are some heavy hitters. Okay. Almost like I wish that this team of attorneys was on the case initially, or maybe just a different set of attorneys was on the case initially. I've told you guys before that I feel like Karmelo Anthony's attorneys literally just failed him. I don't think that they presented the case, their specific case, in the best light. Obviously, defense doesn't have the burden to present anything, but the things that they did present, I feel like were lackluster. The questioning appeared to be mediocre. I don't know. I don't know, you guys. I'm just telling you this. If I ever get a high profile case, I am going to prepare for it like my life depended on it because it kind of does. It kind of does. I just think that the type of preparation, and I'm sure there was preparation, but the type of preparation that was done by Karmelo Anthony's underlying defense attorneys wasn't really that great. Anyways, let's get into who's representing him on appeal. The first of Karmelo's 6 different appeals attorneys is Gary Bledsoe. Mr. Bledsoe is president of the Texas NAACP and has been since 1991. He's also a national board member for the NAACP, and he's a veteran civil rights litigator who's been admitted to practice in the U.S. Supreme Court.
Greatest allies in this work is the NAACP of Texas. And our next speaker, Gary Bledsoe, is the president of the Texas NAACP, and he chairs the National Criminal Justice Committee for the NAACP. I've known Gary for longer than probably we both like to admit. Gary has always been a fierce advocate for justice. Gary has always been a fierce ally of labor. And he's done it in some of the toughest places in this state. And he's not scared. He's not tired. But he is a friend. And he is an inspiration to all of us. This state is not easy to do union work. This state is not an easy place to fight for the rights of all people. But this man has done it his whole life. And I would like for us to give a very warm Texas Union welcome to the president of the Texas NAACP, Gary Bledsoe.
I am honored to be here among you, the greatest people of our state, because without labor, we have nothing. I moved here in 1970. It was not a progressive city at all. The Austin Police Department was headed by Chief Miles at the time, if I remember when I came here. And one of the warnings I got from members of the black community and for folks on the campus was to be wary of the police department because they are not kind to African Americans. And indeed, there were many problems. I can remember my barber is named Tony Terry. In 1976, a police officer, Leland Anderson, was killed by a black man. A mob mentality erupted, looking for some black male with short cropped hair of brown skin complexion. And so they were beating up any black man they could find. Tony Terry had nothing to do with it. He was just driving his car and they stopped him and they beat him up profusely. He was in the hospital for many weeks. They almost killed him. There's been a continued issue with police and police violence against the African American community, and it seems like it doesn't matter who's in the helm there, at the helm. African Americans are not going to be given decent treatment.
Michael L. Ware is the executive director of the Innocence Project of Texas. He has over 40 years of experience, and he was inducted to the Texas Criminal Defense Lawyers Hall of Fame in 2025.
An exoneration and an apology. Lydell Grant was convicted of murder 7 years ago, and he's now a free man, spending his first Christmas at home since the awful day he was sent away. DNA testing has also led someone else to be charged in that case, and that has Houston police saying that they're sorry justice has taken so long. Our affiliate KTRK was there last month as Grant was released on bond.
Lydell Grant's first words to us.
I feel rejuvenated. I feel free now.
And the 47-year-old is free for now, but he understands.
It's not over. It's not over.
Convicted for murder in 2012, prosecutors say he stabbed 28-year-old Aaron Shoehorn to death. He was linked to the crime through DNA testing. But now the Innocence Project of Texas says new and modernized analyzations and tests of DNA prove Grant is innocent. The state agreed to a bond. Now his case will be reinvestigated.
The prosecutor did the right thing, and they agreed to me being out on bond. But I don't really feel like I should be paying to be out when I'm actually innocent.
And it's a huge step in the right direction. But we do have a very, very far distance to go yet before he's finally exonerated. We're confident, very confident that he will be ultimately exonerated.
For now, though, Grant's plan...
Taking it one day at a time.
9 years behind bars, Grant is hopeful he won't go back.
Well, I mean, this step right here, I really believe that the justice system is going to do the right thing.
Tonight, he has a powerful message to those who played a role in convicting him for murder.
Forgive them, Lord, for they know not what they do. Forgive them. I forgive them. That's the advantage that I have over a lot of people. I know how to forgive and I know how to love.
Some powerful words there, right? Again, an arrest has been made in the case. Lydell Grant and his attorney, Mike Ware, from the Innocence Project of Texas, joining me now. Gentlemen, I know it's a busy time. It's the holidays. I thank you both for joining us. Lydell, I have to start with you. I mean, how was your Christmas? First of all, how are you feeling?
I'm feeling blessed. I'm feeling wonderful. I'm feeling
It's a beautiful thing right now. Now I'm just enjoying life, taking it slow, but it's overwhelming right now.
You said in that piece, you said, it's not over. But someone else has been charged with that murder. Why do you say that? Because I would admit that you think justice is probably finally working in your favor.
I said it's not over because we're fighting. We're fighting to the end. I knew that I was actually in it from the beginning, and I came out actually innocent. And finally, they have apprehended the actual killer. Not only have they apprehended him, but he has confessed to the murder. So therefore, that only strengthens my case to prove my actual innocence.
All right, I want to weave Mike into the conversation. Mike, tell us about the Innocence Project. How did you find Lydell's case, and what was the uphill battle like for you?
Well, I'm the executive director of the Innocence Project of Texas, and we're based in Fort Worth, Texas, and we get hundreds of letters every month. And this was one that was able to work its way to the top as a priority in one of our investigations. And because there actually was DNA in this case. And so we were able to get the DNA that was still available in this case reanalyzed. And it not only excluded Mr. Grant as a contributor, it actually, when we were able to upload it into the National DNA database, it actually identified the actual perpetrator of this murder, who has since been apprehended and who has admitted his guilt in this crime.
Mike, some people are probably shaking their head right now. How does something like that happen in the first place?
Well, I think what this case illustrates is how, in our system, how easy it is for a completely innocent person to be wrongfully convicted in the first place, and how completely difficult it is to exonerate a completely innocent person once they have been wrongfully convicted.
Russell Wilson is board certified in criminal law and has been since 2003. He's the former head of the Dallas County District Attorney's Conviction Integrity Unit.
A prosecutor in Fort Worth said today that his job proving a police officer lied about a use of force incident is a pretty easy one. Jason Allen, live for us over at the Tim Curry Criminal Justice Center. This is all connected to a violent takedown that was also caught on camera, correct?
It is, Doug. Testimony just wrapped up here for the day. And over the last hour, jurors were watching that video that you mentioned, both video from a security camera and video from a body camera. And one of those cameras also had audio, and it is that recording, really, that has this police officer here now facing possible time in prison. Fort Worth officer John Romer is accused of telling a grand jury that he had let a man know that he was under arrest before he punched him in the face and took him down. Now, this was at Texas Health Harris Hospital in 2016. Video and audio recordings of this incident show something different, though, than Romer's story. Henry Newsom had just been released as a patient. He was trying to get a family member to pick him up. He started to get frustrated when officers started asking him why he was there at the hospital. And based on the video recordings, officers had him down on the ground before anyone told him he was being arrested.
He lied about whether or not he had told Henry Newsom that he was under arrest. So we have it right there on the camera. You have the audio running, you'll have the video running.
Oh, a cop just really hit me in my face.
Yeah. Romer is also accused in some other court filings related to this case of not telling investigators about all the cameras there, that he had asked another officer to turn his camera off at one point, and that he also grabbed Newsom by the throat when they were together outside. In fact, it wasn't until Newsom sued the hospital and also sued John Romer that investigators realized the whole story, and they started looking into the officer's actions.
Who do you trust with your freedom, your business development, your professional reputation? Putting your legal issues in the wrong hands is a catastrophe waiting to happen. I offer over 24 years of expertise representing professionals in all capacities, whether defending a person against a serious criminal charge or another serious legal matter. Simply ensuring that actions are taken to protect professional licensure or representing small to medium-sized businesses. As a former leader in the Dallas County District Attorney's Office, I developed a unique legal skill set that combines years of courtroom and classroom experience to assist with legal issues arising everywhere from the back room to the boardroom. Throughout my years of service, I've won a myriad of state and federal cases at trial and appellate levels. One simple mistake can lead to a lifetime of regret. Educating people with extensive knowledge and a guiding hand makes all the difference. When the stakes are high, you need strong, effective counsel. Call my office today and let us help you.
Brooke Cluse is a high-profile civil rights attorney, and she works with the Benjamin Crump law firm.
Now, a question for families that may go through something like this. What rights do families have when they believe an investigation isn't being handled properly? Where do they go?
It's a hard question. It's a hard question because you go to the police, right?
Mhm.
That's where you're supposed to go. And when the police don't respond, then what do you do? So, at Ben Crump Law, we're a court of public opinion. Meaning we truly believe in the court of public opinion because there we can tell stories, we can ask the public to help us with transparency, and then we can demand transparency from officials who are investigating, whether it be an excessive force case, whatever case that we have. And so that's what we do, and that's what a lot of people do. And unfortunately, if law enforcement isn't helping, then you may have to get an attorney. And these cases, again, our co-counsel said yesterday, it is not our job to investigate crimes. It is the job of the police and law enforcement, right? So that is going to be your first option. But if they're not willing to help, then you may have to seek assistance from an attorney to put pressure on law enforcement.
Justin A. Moore is an experienced criminal defense attorney and civil rights advocate.
Nearly 7 years. Imagine for a second having the threat of going to prison hanging over you for nearly 7 years, all for an honest mistake that you made at a polling booth, of all places. And that's exactly the nightmare that Crystal Mason has been living, a nightmare that came to an end just last night. And it all started when Mason cast her vote in the 2016 election. One problem, though. She, at the time, was on a supervised release after serving time for tax fraud when she filled out her provisional ballot, something not permitted for felons on probation under Texas law, and something that she says she had absolutely no idea about.
I thought I was exercising my civic duties by feeling about voting. I thought I had that right, and yet I am facing 5 years for innocent, nonviolent offense.
You heard her right. She was facing 5 years in prison, and in that time became a kind of poster child for the right's steady drumbeat of voter fraud. But last night, a Texas Court of Appeals threw out the conviction. Crystal Mason and her attorney, Justin Moore, join me now. Crystal, thank you so much for being here. I could not believe when the news of this story came out, let alone what you have been through, which has been a nightmare. Now that you have been completely exonerated, how are you feeling, Crystal?
I am right now just overwhelmed. I am just overjoyed with my fate, thanking God for just keeping me sane through this whole journey. It's been 7 years. 7 years, 6 years I've been out on an appeal bond. 1 foot in and 1 foot out, not knowing if I'm going to prison or not. So this has been very, very hard. But I am just so grateful. I'm really in shock right now. Like, is this real?
You're a mother, just like me. You have 3 children, though. And I wonder what it's been like for you and your family to cope with this threat hanging over you guys for all these years.
Very difficult. You know how you don't want, you hope for the best, but you got to prepare yourself for the worst. So you want to make sure that you have someone in place that can maintain your bills, maintain the things that you have. So if I do have to go, I'll at least have somewhere to come home to. So it's been very, 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 very hectic on my family.
I mean, Justin, I can't imagine this. And just thinking about parents want to know who their emergency contact might be for their children. They want to know that they'll be provided for. For 7 years, she's had to battle this for what the court has obviously found to be a completely innocent mistake. And one of the things that Crystal has said in the past is I was thrown into this fight for voting rights and will keep swinging to ensure no one else has to face what I've endured over 6 years. Justin, what has this fight been like?
Well, I mean, the fight has been very stark and bleak at times, but we always maintain hope. When I got involved, this was after the trial court made their determination to convict her to 5 years. And when we got involved with me and the other attorneys, when we filed our motion for a new trial, we knew that there was something there to make sure that Crystal didn't have to spend the 5 years of her life in prison for something so heinous. And I'll say this, I know everybody's casting this as a mistake, but this was a malicious prosecution. There was nothing that Crystal could have done to prevent that, right? She went to her polling location. She spoke with the poll workers there, and they should have told her about her inability to vote. But instead, they allowed her to, and they insidiously reported that to the district attorney's office. And we all know that Tarrant County is one of the largest red counties in this country. And we know at the time that that district attorney was someone that really liked to play and be involved in political theater. And they used that. She used that. And she used Crystal's life as cannon fodder for this continual drumbeat of this very false narrative of illegal voting that we know is a false narrative.
And if I'm not mistaken, it was a provisional ballot, right? So you routinely will cast these ballots and for people who are not sure if they're supposed to and whatnot. That's almost the crux of why you have them. But this case, Justin, was thrown out by the Court of Appeals because the prosecution didn't have the evidence. I just want to read for everyone here, Crystal, what the court said. They said, quote, "We conclude that the quantum of the evidence presented in this case is insufficient to support the conclusion that Mason actually realized that she voted knowing that she was ineligible to do so, and therefore insufficient to support her conviction for illegal voting." What was, Justin, the key piece of evidence that led to this acquittal? And by the way, what took so long?
Well, the key piece of evidence was that there wasn't any evidence. And Laura, you're a former prosecutor. We know that prosecutors around this country, they're charged with the ability, but also with the burden to not bring forward cases that they can't meet all the elements to. And the fact that they pushed this case through to essentially try and throw this woman's life away is completely heinous.
And Sean Daredia, no sé cómo decirlo, is an appellate and defense strategist.
The legal teams have agreed to add a claim of sudden passion as a consideration as the jury considers punishment. NBC5's Shannon Miller joins us now live with a closer look at what that means and how this verdict came down. Shannon?
Yeah, Meredith, we've been speaking with defense attorney John Daredia and former state prosecutor on all of this, and we talked a little bit about that instruction. And Maria Guerrero just reporting that the paper copy of the punishment for the jury instructions has just come down. Again, all of this wrapping up the sentencing part of those closing arguments, Sean, around 4:37 this afternoon. We went to sentencing, and Karmelo Anthony, the defendant, still not called in all of this. A lot of people asking, why didn't he take the stand? Are you surprised by this still?
I am surprised. I am shocked. I am utterly confused. At sentencing, you want to humanize your client. That gives you the best opportunity to get him the best outcome, to get him the least amount of prison time. Without Karmelo testifying, without him talking to the jury, they can't see that remorse. They can't feel that remorse in his heart, in his voice, in his eyes. They can't humanize with him. And without him taking a stand, him being able to connect with that jury, that gives a jury no reason to give him a lesser sentence. And I think strategically the defense didn't want to call him for whatever reason, but I think it was a big misstep because he's already been convicted of murder. That's done. He's been convicted. You have nothing else to lose at this point. And if I had been on that team, I would have called any and everyone. I mean, teammates, friends, people that have interacted with him, because the jury really needs to at this point connect with him. They need to see a human. Right now they've convicted him as a murderer. Well, when they go back for sentencing, you want them to not see him as a murderer, but as a child, as a friend, as a brother, as a community leader. And I think the jury needed to hear more. And I think you mentioned earlier, what do you think the sentence will be? I can't give a number, but the fact that the jury didn't hear from those witnesses, they didn't hear from Karmelo, I think that potentially may lead to a large prison sentence for him.
And coming down with that verdict in just a matter of hours could be just as quickly here with that sentencing. Sean, we appreciate your insight. We'll continue to watch all of this for you throughout the afternoon. Meredith, we'll send it back to you.
Okay, you guys, so those are the key players that are handling Karmelo Anthony's appeal. So just keep those people in mind as we go through this lengthy document. So as you guys can see here, it says the state of Texas versus Karmelo Sincere Anthony defendant, cause number 296-83565, 2025, in the 296th Judicial District Court, Collin County, Texas. Defendant's motion for new trial and brief in support. To the Honorable Judge of said court, 1. Comes now defendant Karmelo Sincere Anthony, by and through undersigned counsel, and pursuant to Rules 21.1 through 21.9 of the Texas Rules of Appellate Procedure, moves the court to set aside the judgment of conviction and sentence and grant a new trial. The defendant moves for a new trial on 4 grounds. First, the court committed structural error when it materially restricted public access in violation of the right to a public trial. Second, the state's repudiation of the parties' unrecorded evidentiary agreement after the defense relied on it coerced the waiver of Mr. Anthony's right to testify and denied him a complete defense in violation of his constitutional rights. Third, the trial court improperly instructed the jury on the applicable law. And fourth, the cumulative effect of these errors warrants a new trial in the interest of justice. Okay, you guys, I'm going to stop right there. Okay. So before reading anything further, because I'm reading this with you guys, okay, and I'm interpreting it with you guys, I will say this. As far as the first argument is concerned, without knowing anything other than that one sentence right there, I don't agree with it. I don't agree with it. As we talked about, every defendant is entitled to a public trial, so he has the right to a public trial, but public doesn't mean broadcasted across the United States of America. That's not what public means. Public just means that the courtroom doors are open and people can go in. So without knowing anything further, if that is what they're talking about, that it wasn't filmed, I don't agree with that. But it might be more to it. Like maybe the doors were locked or people didn't have access, or like there might be more to it. So let's see. Okay. As far as the second argument is concerned, I have been hearing about some gentleman's agreement, some little handshake and nudge that the parties had. And by virtue of that agreement, Karmelo Anthony did not testify or something like that. I don't know what the agreement is. So just based on this sentence alone, I'm quite intrigued to see what exactly was the agreement that was in place and whether or not the prosecution violated it in such a manner that violated Karmelo's constitutional rights, but we'll just have to keep reading and seeing, okay? The third, and I don't know if I've ever shared this with you guys, but unequivocally, the most or the main reason that I have ever seen convictions be reversed is because of jury instructions. So if there's a bad jury instruction in here, and is that what they said? The bad jury instruction, right? I can see that as a basis for the conviction being overturned and the sentence being overturned. And the fourth is basically just a catch-all. Because of all these things, the conviction needs to be reversed type of thing, right? So yeah, that's where we're at. Those are my general opinions, but let's just go ahead and carry on and see what else they say. Introduction. This case presents a structural public trial violation. The court had authority to manage courtroom security, decorum, and capacity, but once it adopted and administered restrictions that foreseeably excluded members of the public from a high-profile criminal trial, it was required to make record-supported findings and to consider reasonable alternatives to closure. The court did neither. The access regime limited public attendance to a narrow daily admission period, a small number of seats, and no continuing overflow or audio or video access after jury selection, because that closure affected the trial proceedings themselves. And for the 3 additional grounds set forth in this motion, defendant asks the court to set aside the judgment and grant a new trial. In support, defendant shows the following. Okay, you guys, let me just stop right there and kind of explain that to you. So it doesn't appear that they're arguing what I said, which is good, because if they were, I wouldn't see that as a viable ground, right? I do believe it's not required that there be cameras in the courtroom. And I didn't read anything in here about cameras in the courtroom. Basically, what they're saying is, Judge, you restricted the general public from attendance from a high-profile case, but you didn't make any records to support the basis of your restriction, basically, right? And so they're talking about the fact that even if people went into the courtroom, they were restricted because this was such a high-profile case. And the court also didn't allow for overflow rooms, which is also kind of problematic. I'm gonna relate this to another high-profile case that we discussed on this channel, and that's the case of Sean Diddy Combs. As you guys know, in federal court there is no cameras, so that one was not recorded. But there were members of the public who were allowed to go in, and the court also had overflow rooms because this is a high-profile case, and people were literally flying to New York City to see Diddy be tried. That's what the court did, right? And so, if this court did not do the same, and Carmelo's attorneys can show that by not doing the same, it restricted his access to a public trial, that might be valid. That might be valid, but let's go ahead and carry on. Factual background. The case and the verdict. This case arises from an altercation at a high school track meet. The defendant, Karmelo Anthony, was charged by indictment with the murder of Austin Metcalf, alleged to have been committed on or about April 2nd, 2025 in Collin County, Texas. The defendant pleaded not guilty. His defense at trial was self-defense, that he used force he reasonably believed immediately necessary to protect himself. The court's charge submitted the offense of murder, the lesser included offense of manslaughter, and the law of self-defense, including the justified use of deadly force. The defendant did not testify. On June 9th, 2026, the jury found the defendant guilty of murder, and the court imposed a sentence of 35 years confinement. These matters appear from the indictment, the court's written charge, and the judgment. The case drew national attention from the outset, and the court appointed a public information officer to assist with media credentialing, communications, and access logistics. In practice, public and media access were administered through that process. What follows is how the access was in fact administered: before trial, at the perimeter of the courthouse campus, at the courtroom door, and after the verdict. Secrecy before trial, the gag order, chambers conferences, and no public pretrial hearing. The closing of this prosecution to public view began more than 10 months before trial. On July 28, 2025, acting sua sponte and on no party's motion, the court entered an order prohibiting extrajudicial statements, a gag order binding the parties, their attorneys, witnesses, law enforcement personnel, courthouse and court staff, and court-appointed officials, which by its terms remained in force through trial. Covered persons with first-hand knowledge were restricted from speaking publicly about the facts, evidence, witnesses, and expected testimony absent written approval from the court. The gag order's terms were sweeping. Unless first approved in writing by the court, no covered person could make any extrajudicial statement that addressed the character, credibility, expected testimony, guilt, or innocence of any party or witness, that discusses evidence anticipated to be introduced at trial, or that intends or is likely to influence public opinion or potential jurors. Restrictions expressly applicable to any public medium, including traditional news outlets and social media, and enforceable by contempt, fines, attorney discipline, or other remedies. Its findings were 3 sentences: that media coverage has the potential to cause imminent and irreparable harm to the defendant's right to a fair trial, that alternative measures, venue change, jury screening, sequestration, would be inadequate alone, and that narrowly applied speech restrictions are necessary to protect juror impartiality. No evidence is recited. The order permitted only procedural announcements and statements required by legal or ethical duty. A safe harbor that presupposed filings the public could see. By its terms, it would yield only to further written order of this court, and the amended order later reaffirmed it, until the completion of trial. In the 10 months it operated, no person was ever alleged to have violated it, so far as the public record reflects. The substantive pretrial work of the case was then conducted outside of the public view. The parties' pretrial conferences with the court, including a May 21, 2026 conference in chambers, at which the parties' evidentiary understanding was described to the court, and a May 29, 2026 meeting addressing trial security and scheduling, occurred in chambers outside of open court. No reporter's record of them exists, a matter the hearing will confirm. No pretrial hearing was ever held on the access restrictions, and the register of actions reflects no such setting. The public docket discloses no motions in limine, and none of the substantive pretrial litigation that in fact occurred, filings that were hand-delivered rather than filed in the district clerk's public record. A member of the public who examined the docket before trial would have found no hearing to attend and nothing to read. Okay, let me stop right there, you guys. I think, based on just my reading of that, I think that argument is persuasive. And let me tell you why. Because not only is the defendant entitled to a public trial, and by my definition of public, not necessarily meaning cameras are everywhere, they're entitled to public hearings, they're entitled to public proceedings, they're entitled to public everything, right? The whole criminal process is public, right? So if what they're saying is there are two separate hearings that occurred outside of the public purview, meaning the members of the public could not even access the hearing. I hit myself, sorry. And they were held inside of the judge's chambers. I think that is extraordinarily problematic because Karmelo is entitled to a public everything. Okay, everything. But let's go ahead and carry on and see what else they say. The amended order, the written terms of access. On May 18th, 2016, the court signed the amended order regulating trial proceedings, media access security, and courtroom decorum, entered to govern all aspects of the trial proceedings. The order recited the directives of Waller v. Georgia and Shepard v. Maxwell, found that unrestricted access or activity may compromise courtroom security, juror privacy, and the defendant's right to a fair trial, and promised reasonable public access consistent with constitutional requirements. Its operative terms were these. The courtroom would open at 8:30 for the media, at 8:40 for the designated family members, and at 8:50 for the general public. No more than 9 members of the media would be admitted. Seating would be on a space available basis. The doors would close promptly at 9 a.m. Individuals arriving after that time would not be admitted until a recess, and no person who left could re-enter except at a recess. All persons attending were required to dress in appropriate business attire. Hats and caps were prohibited, and clothing or items displaying messages, logos, symbols, or images related to the case or otherwise distracting or potentially prejudicial were banned. The order appointed Steve Stoller, identified in the order only by a personal email address and cell phone number, as the court-appointed public information officer, committed media credentialing to that office, and announced that the court would not intervene in or resolve disputes among members of the media regarding access or seating. The order contained no provision for an overflow room, an audio feed, a video feed, or any other means of observation for members of the public turned away, and no mechanism by which a member of the public could be heard to object to any of it. The order also closed the courthouse grounds themselves. It placed the entire courthouse campus, including parking lots, sidewalks, green space, or any other designated area, under a nightly curfew from 11 p.m. to 6 a.m. beginning May 31st, 2026. It designated restricted zones on an attached exterior map, and it ordered the Collin County Sheriff's Office and other law enforcement personnel to ensure compliance with this order at all times during trial. Under the order's enforcement clause, any violation, including a citizen's presence in a courthouse parking lot or on the green space between the courthouse before 6 a.m., expose the violator to immediate removal from the courtroom, courthouse, or courthouse grounds, and the imposition of sanctions, including contempt of court, and no warning is required prior to enforcement. No findings of any kind accompanied the curfew. Access and operation, the curfew, the parking lot, and the pre-down line. In operation, admission had almost nothing to do with the order stated 8:50 a.m. public entry time. Because the public seats were few, members of the public began arriving in the pre-dawn hours, often between 4 a.m. and 5 a.m., before court was in session and while the campus curfew was still in force, and sheriff's deputies enforcing the order stopped arrivals at the parking lot and restricted entry onto the campus until the curfew lifted at 6 a.m. The queue that actually determined who would see this trial thus formed at the perimeter of the courthouse campus hours before any proceeding convened. A member of the public who appeared at the order's appointed hour at 8:50 a.m. had, as a practical matter, no prospect of a seat. The line itself was administered without published standards and not even-handedly. Individuals were permitted to move ahead of the members of the public who had already waited for hours. Thelma Anderson, who arrived on June 6th and initially held approximately the 7th position, was displaced to approximately 35th, beyond the number of seats available, and was excluded from the morning's proceedings. Temetra Carter, identified as number 7 on an early arrival list, was removed from line on June 5th and lost the morning session. Admission was run through 2 lines. one for a media list, one for everyone else. And media outlets denied credentials were directed by public information officer to seek entry through the public line, whereas a Collin County Sheriff's deputy administering the line acknowledged on video persons who print out whatever and make themselves like they are media consume the public's few seats, a practice the officers conceded they could not police. Okay, you guys, let me stop right there, okay? So this seems problematic to me. I'm going to be quite frank. This seems problematic to me. So if the court is limiting people, like members of the public, from accessing the room, but there's no specific requirements as to how the limitations occur, how are people supposed to know, right? I don't know if there are people that the appeals team either spoke to or got information about. So maybe there's a general list that were earlier in line, but then moved to later in line. And knowing that the position that's later in line would not have access to the courtroom and there was no regulation as to why that happened or how that could happen, I think that's very problematic. But let's go ahead and continue and see what else they say. Inside the courtroom, 24 public seats and an overflow room provided and then withdrawn. The courtroom held approximately 76 seats. By the court-appointed public information officer's own written account, 15 were allotted to the prosecution's family, 15 to the defense's family, and 9 to the media, including a courtroom sketch artist, with additional seats for court staff, leaving about 24 or so seats to the general public. The trial judge later confirmed the arithmetic on television. Some 200 requests by the media, and 27 to 32 public seats that we rotated every day. None of these allocations appear in any order, and the 15-seat family allotment was not honored in practice. The defendant's own family was limited to 8 seats in total, so that his grandfather and his aunts were excluded from his trial, while those admitted were required to register a day in advance and were warned that visible facial expressions could result in removal. For jury selection, the court furnished what its order had never promised: an auxiliary viewing location outside the courtroom, a functioning overflow room, where members of the public who could not be seated inside observed the proceedings on June 1st and June 3rd, 2026. On June 4th, 2026, the first day of testimony, the court eliminated it. No announcement was made in open court, no order was entered or modified, and no findings were made. Public access was thereafter confined to the seats inside, nor was the elimination a reaction to anything that occurred at trial. As early as May 25th, 2026, the public information officer had advised an inquiring journalist in writing that there will be no overflow room during the trial. This, although the county's own media request intake form listed overflow room access among the accommodations that could be requested. When Thelma Anderson asked the court for an alternative viewing location, there was no way to even file the request. The county's electronic filing system had no category for courtroom access request in a criminal case, so the request was routed by email to the court coordinator and on to the public information officer, and it was denied outside of any judicial proceeding. On June 5th, the public information officer confirmed in writing there is no overflow room. Day by day, the accommodation existed only when no witness testified. The pattern is visible day by day. During jury questionnaire and voir dire, June 1st and June 3rd, an auxiliary viewing room accommodated the members of the public who could not be seated. On June 4th, the first day of testimony, the room was eliminated, and on every documented day of testimony thereafter, members of the public were excluded. The accommodation existed precisely when no witness was testifying and vanished precisely when the evidence began. Okay, you guys, let's stop right here. What we're going into is the chart that Karmelo's appeals attorneys are claiming show or prove their point that members of the public were excluded when evidence was being presented and when witnesses were testifying. So just look at that. I'm not going to read it to you, but I'm going to just give you guys a moment to look at it yourselves. But keep that in mind as you're looking at it. The excluded public. The exclusions that followed were repeated and concrete. Jacqueline Yon traveled from North Carolina and on the first day of testimony found a line of roughly 80 to 100 people, from which only about 27 were admitted. Tara Allen flew in from Arizona, observed jury selection from the auxiliary viewing room, was told on June 4th that the room had been eliminated, and was excluded from the courtroom on June 4th and 5th. Bridget Smith attended on June 1st, 4th, 5th, and 6th, and confirms both the roughly 27-seat public cap and the elimination of the outside viewing location once testimony began. Kiera West was turned away on June 1st on a purported jury members only rule and was physically removed from the courthouse on June 6th. Thelma Anderson was excluded on June 4th and June 5th, and on June 6th was seated only in mid-afternoon after substantial portions of the day's proceedings had passed. Throughout, no declarant observed any disturbance, security incident, or disruptive conduct by any member of the public that would explain the restrictions. The unrecorded agreement, the defense tried its case under that limitation in reliance on an understanding reached off the record. Okay, you guys, I'm going to stop right here before we get into anything else. And just based on that heading, I'm just going to tell you my opinions before I read any other words, okay? I think it is absolutely asinine, ridiculous, volatile, foolish, and amateur for any parties to any sort of formal proceeding, be that a criminal case or be that a civil one, to have an off-the-record agreement. That is stupid. That is stupid, okay? So let me just start there. I know I've taken, time in criticizing Karmelo's defense attorneys, the ones that he went to trial with, and I guess here I am continuing. But I just think that's ludicrous to have an off-the-record agreement. I don't know what this agreement is just yet, but let me just say this. I don't think there's a single time that I have ever had an agreement with any member of the opposing side ever that I did not put on the record. So let's assume that it's not something that needs to be written out, right? Whatever. I'm gonna still make a record to it. Yes, Your Honor. So-and-so and I came to the agreement that XYZ. Why is it not on the record? Who agrees to things and don't put it on the record? Oh my Lord. Mind blown. Mind blown. But let's go ahead and continue. The same off-the-record method that hid the pretrial proceedings from the public also produced the understanding on which the entire defense was built. Beginning in early May 2026, the lead prosecutor proposed that the parties try the case clean, based only on what happened under the tent that day, with neither side offering character, reputation, or extraneous conduct evidence concerning either the Metcalf twins or the defendant. The terms were negotiated in meetings and calls on May 5th, May 8th, and May 11th, and on May 21st, 2026, the parties presented the understanding to the court itself in chambers, but off the record. To avoid media reporting on bad act evidence, the understanding was memorialized only as a deliberately generic motion in limine, hand-delivered to the court on the first day of trial. It does not appear on the public docket. Let's stop right here. This court is having a lot of off-the-record hearings, and I find that a little bit problematic. But if you guys will remember one of my first videos when I talked about this case and I talked about the key players, Judge Roach is retiring. Like in a few months, I believe December of this year, 2026, is literally his last day, right? So it's like, what's it to him? But all of these off the record agreements and all of these off the record and just in chambers things that are happening right now are just ludicrous. I'm not saying things don't happen off the record occasionally. I can probably count throughout the entirety of my career how many times I've ever done anything off the record. I'm so astonished. Let's go back to my first thought. I still can count on one hand how many times I've done anything off the record my entire career, and I can probably count it down to 0 fingers. I'm being honest. I don't do off the record things. You have to make a clean record that protects both the client and the prosecution from any misunderstandings. It has to be on the record. The fact that Karmelo's defense attorneys would think that it was proper, appropriate, professional, or a good idea to not protect his best interests by putting something on the record is an abomination. I think I got it all out there. Let's go ahead and carry on. From that point forward, the defense tried its case under that limitation at every stage in reliance on the bargain. In voir dire on June 3rd, the defense did not explore with the panel the themes of the decedent's character and aggression it otherwise would have developed. In its opening on June 4th, it introduced none of them. Through the state's case on June 4th, 5th, and 6th, the defense let the state's students leave the stand without confronting them with their own recorded statements to police. That Austin Metcalf was kind of like the aggressive guy on the team and that he got triggered. That Austin and Hunter, they're not going to let you disrespect them. That if Austin is about to get into a fight, you can tell. And that he could be a bit aggressive at times. And in an abundance of caution, even narrowed the questioning the understanding permitted. The defense designated no experts, foregoing a neuropsychologist prepared to explain how the defendant's epilepsy affected his perception of threat, and a forensic psychologist prepared to address adolescent brain development and the fight or flight response, because the state took the position that such testimony would breach the understanding. I'm going to stop right here again and tell you guys, I'm kind of disappointed to hear that the agreement was even entered into from the beginning, right? Because I think a lot of this case, this trial in particular, relied heavily on the characters of the two people that were involved in it. So if the prosecution wanted to introduce testimony about Karmelo's character, whatever testimony they believe they had about it, I, as the defense attorney on the case, if I were one, I'd be like, I welcome it, carry on, and we'll talk about the decedent's character as well. I think that this whole clean fight thing is silly, or I'm sorry, clean case thing, like clean trial, like there's no really cleanness in a trial. Like both sides have a stake in the trial. Like gloves come off, like you be professional, but you have to do your job. And I just don't think by virtue of what we're reading here that they did their job. Literally at all. Let's go in a little bit further, but then I'm going to stop. And I know we haven't gotten super far, but I'm going to stop just because I don't want it to be super overwhelming. And then we'll pick back up in the next video if you guys would like. The forbearance had a purpose. The payoff was to come in the defense case, under the understanding, as the prosecution itself repeatedly described it, covering all witnesses to what happened under the tent. The defendant would testify to the altercation like any other tent witness, free of character impeachment, and the defense would present its self-defense case through him. Every pretrial discussion presupposed it. The prosecution repeatedly raised the ambiguous aggressor doctrine that matters only in a self-defense case built on such evidence, and as trial counsel has sworn, in this case, the defense would ordinarily depend on the defendant's own account of his perception of the threat. On Monday, June 8th, the final day of evidence, after the defense had spent voir dire, its opening, the entire cross-examination of the state's case, and the first day of its own case, honoring the bargain, the lead prosecutor announced that the agreement had never contemplated a testifying defendant, and asserted that the defense counsel had already opened the door by mentioning in opening that the defendant played chess, a position the court itself rejected. The court then advised the parties that it knew of no mechanism at its disposal to enforce their understanding, an understanding that throughout the months the defense relied upon it existed on no record because it had been reached and presented to the court off the record, and that if the defendant testified, the door to character and extraneous offense evidence would almost certainly open. Allotted 10 minutes, the defendant elected not to testify. By then it was too late to conduct a different voir dire, deliver a different opening, or recross the state's witness, and at punishment, the defense case was reduced to 3 pre-approved questions of the defendant's mother. The state, for its part, called no punishment witnesses and offered none of the extraneous offense or character evidence cataloged in its 75-page notice, resting its punishment case immediately, exactly as the lead prosecutor had described on May 11th that the agreement would operate. The state thus performed the bargain at punishment that day after denying the same bargain covered the defendant's testimony. In the end, neither side put on the character evidence the understanding covered. The bargain was performed on both sides through the last day of trial. The only term repudiated was the one most vital to the defense, the defendant's own testimony. Karmelo Anthony was necessarily a witness to what happened under the tent, under the understanding, as the state itself had repeatedly described it. He would testify like any other tent witness, and his elimination as a witness was devastating to a defense that turned on his own perception of a threat he faced. By then, the defense had already paid the price of reliance and could not undo the voir dire, opening cross-examination, expert designations, or decision framework that followed from the understanding. Can I just stop right here and tell you that this is why I don't do off-the-record agreements for this purpose, right? I'm not saying that the prosecution was shysty in this case because this specifically is an argument made by the appeals team, right? If the appeals team can prove that the prosecution was this shysty and now they're trying to go back on an agreement that the parties made off the record. I think that that's going to be pretty damaging. I do. I think that's going to be pretty damaging. But this is why, from my perspective, you don't have off the record agreements. Literally ever. You guys, I'm trying to tell you, my mindset when it comes to practicing law is trust but verify. Okay? And I just think that's how you need to practice law. Trust but verify. Do I trust the other side telling me that this is the agreement that we're entering into? Sure. But am I going to make sure to cover myself by putting it somewhere on the record so all parties are of the same understanding? Absolutely. The fact that someone who's been practicing for 20 plus years, and I believe that's what Karmelo Anthony's attorney, Mike Howard, right? I believe that's what he said, how long he's been practicing, would do something so amateur is quite pathetic. It's quite pathetic. Okay. Let's carry on into a few more things, and then we're going to conclude this video so we can just pick back up in the next one. The expedited schedule, Saturday court in 10 minutes to decide. The trial itself was run at speed. At the May 29th conference, the court announced its intention that the defense began calling witnesses immediately upon the state's resting so that no trial day would go unfilled, including Saturday, June 6, 2026, a day on which several defense witnesses were unavailable. Trial counsel told the court that the schedule could force the defense to call the defendant out of order. The state rested midday Saturday, and the defense began its case that afternoon. The repudiation of the parties' understanding, described above and set out fully in Part 4 below, erupted on Monday, June 8th, the final day of the evidence. When the moment came for the defendant to make the most consequential decision of the trial, whether to waive his Fifth Amendment privilege and testify, the court allotted the defense 10 minutes to counsel a 19-year-old through it and denied counsel's request for additional time. The defense rested that day after the shortened session, and the jurors were sequestered overnight in a hotel, informed that if they did not reach a verdict on Tuesday, they would remain sequestered. On Tuesday, June 9th, 2026, the court delivered its charge. The parties presented closing arguments, and the jury deliberated approximately 3 hours before finding the defendant guilty of murder. The punishment phase, evidence, argument, deliberation, and the rejection of sudden passion was then completed, and the 35-year sentence imposed before the day ended. The sequestration and deliberation chronology, widely and publicly reported, will be established at the hearing and confirmed by the reporter's record. After the verdict, the sealed file, the missing record, and the televised defense of the closure. The secrecy outlasted the verdict. Trial counsel withdrew on June 10th, 2026. Appointed appellate counsel was then replaced, and present counsel were substituted in on June 23rd, 2026, all while the 36-day deadline for this motion ran. The reporter's record remained wholly untranscribed, and the pleadings and case file sat in the court's chambers rather than in the district clerk's public records sealed by an oral order. At a conference on June 29, 2026, the court advised that the entire court file had been sealed by order and conditioned counsel's inspection of it on an agreement not to disclose what he had observed. A condition counsel could not give, leaving the file available only in chambers. 2 days after imposing sentence, the trial judge gave a televised interview defending the restrictions, describing the decision to bar cameras and streaming as an easy decision, acknowledging that he sometimes thinks maybe he should have at least audio streamed or something so people could hear it, and explaining he declined to do so because people are going to distort whatever happened, so what was the point? In a written statement to Fox News, the judge added, "Now that the trial is over, it's important to me to provide transparency." And in a public letter on June 17, 2026, he thanked the other judges of the county for adjusting their own dockets to accommodate this trial. At minimum, raising a fact issue about available courthouse space, available staffing, and available alternatives that should have been considered before the overflow accommodation was withdrawn. Because the reporter's record of the trial has not been prepared, the official court reporter has advised counsel that no portion of the trial has been transcribed, and because the case file had been held in chambers rather than in the district clerk's public record, the recitation above is drawn from the indictment, the court's charge, the public docket, the court's own orders and public statements, the attached affidavits and declarations, and counsel's knowledge. Defendant will offer evidence at the hearing in support of the grounds timely raised herein. You guys, this is insane. Let me go back to something that counsel said that I don't necessarily agree with, but I'm just going to point it out to you, right? So one of their arguments, which I think they have the right to make, and it's a proper argument to make, but one that I don't necessarily agree with, is the fact that they said that defense counsel only had a few minutes to counsel 19-year-old Karmelo on whether or not he wanted to testify, and that wasn't enough time, and that the court denied defense's request for additional time, and they found that to be improper, and I don't agree. And the reason I don't agree with that is because as a good defense attorney, you should be talking to your client throughout the entirety of the trial, right? So the 10 minutes that the court allows you to talk to your client, or whatever time it was, should not be the only time that you're talking to your client. You should be talking to your client regardless, and you should have had conversations with your client regardless about his right to testify or not to testify, right? And in a lot of colloquy that the court will give to the defendant in front of counsel and on the record, they'll say something like, you know, you have a right to testify. Don't quote this, I'm just spitballing. You know, you have a right to testify. The right is yours and yours alone. No one can take that right away from you. You can testify even against the advice and wishes of your own counsel. Have you had an opportunity to speak to counsel? Yes or no? They inevitably say yes. Do you need more time? They inevitably say yes or no. I have never heard a judge not ask if the defendant needs more time. That's just a question. It's a colloquy. That's just a question. But before that, preceding that colloquy, is the question of if you had time to talk to them already. And I just feel like defense in this specific case didn't counsel him appropriately, I guess, based on this gentleman's handshake that they failed to put on the record. But anyways, you guys, that's enough of me yapping for this video. If you guys want... Actually, I'll go ahead and do it. We'll continue on in our continued coverage and just specifically breaking down this brief counsel's arguments for a new trial and their brief in support of, okay? So that's it for this video. Before I let you guys go, if you guys like this video, can you tell me you like it? Remember, I have memberships on my channel now. So if you want videos like these at least a day earlier than everyone else, go ahead and subscribe. Oh, I'm lying. Go ahead and join and become a member. But otherwise, if you like this video, please tell me you like it. Go ahead and like this video, subscribe to my channel, leave me comments down below, and thank you guys so much for your continued support. As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.